All right, well, thank you. Welcome again, everyone. We've had great panelists so far. We're looking to spice things up here with our activism panel. So get ready for some questions. You know, what we want to talk about here today, again, obviously are recent developments in shareholder activism, but also kind of go through an activist situation, be very practical for all of you, for everyone on the line, and go through a situation, go through the thought process of what do activists look for? What is activism? What tactics are used? What does the general counsel and the board look for when and advise when an activist situation arises? So we want to be really practical. So think about some of these practical questions as we go through this. And all of our panelists are perfectly suited for this topic today and how we want to go through it. Some quick introductions. And again, super thanks for everyone for being available and participating. We want to always promote our panelists and all of you that are taking time out of your day to come and attend. We're very grateful for your attendance and your participation. And I'll start with Michael Levin, who is the founder and editor of The Activist Investor. Visit his website, www.theactivistinvestor.com. I'm sure many of you have already researched Michael, whether that's good or bad. He's a well-known and respected investor, corporate executive, shareholder proponent, more than 30 years of experience in this area. So it's pretty easy to find Michael out there on the internet with his white papers and his thoughts, and we're super happy to have you with us today, Michael. Next to me is Chris Eck, who is the Chief Administrative Officer and General Counsel of Authentix, Inc., and the former Senior VP, General Counsel, and Corporate Secretary of the Finish Line, Inc. Chris and I have worked together for a long time, but Authentix is a global leader in providing physical and software-enabled authentication solutions to detect and prevent counterfeiting and illicit trading in currencies, goods, consumer-branded products. So really interesting business that Chris is involved in now. But during his time at Finish Line, and really the reason we wanted him here today, Chris was in charge of the entirety of the company's legal function and was involved in some of the most complex shareholder activist situations that one could imagine, and he'll tell part of his story today. So we're really happy to have Chris with us today. Next to Chris, we have Professor Ann Lipton of the Tulane University Law School. Professor Lipton's the Associate Dean for Faculty Research at Tulane, a highly accomplished, respected professor of business and securities law and scholar. She has clerked for former Associate Supreme Court Justice David Souter and also spent time at the SEC. So we're very happy to have your perspective with us today. And then also with us online on the screen is Tiffany Posil, the Chief of the Office of Mergers and Acquisitions at the Securities and Exchange Commission, where she oversees the administration and interpretation of the federal securities law requirements on tender offers, proxy contests, beneficial ownership reporting, going private transactions. So a number of areas that are relevant to the shareholder activism situation. So we're very happy to have you, Tiffany, and hope you can hear us okay. So let's get started and jump right in. Just again, level setting. We'll start with something that may seem elementary to all of you, but it's good to level set what we're really talking about here today is what do we really mean by shareholder activism? What is it? Activism has traditionally meant efforts, actions by shareholders to influence corporate behavior, corporate governance through various tactical actions such as shareholder proposals, formal proxy solicitations, and even non-public private campaigns with management and the board, again, with the point of changing corporate behavior. But what also has developed over the years is a form of activism in which the shareholder purchases a significant amount, a significant position in the company, a non-controlling position in almost all cases, and uses that position as leverage to obtain an audience with the board or management and to achieve certain changes. Again, what we talked about before. But the idea of what activism is expanding from a more governance-focused situation to both an economic and financial activist point of view. And in some cases, that results in a sale of the company. So that's really what we're talking about today. And it's important to know that as context. Shareholder activists take many different forms, primarily hedge funds, large public employee and pension funds, sector-specific investment management firms. I do a lot of work in the banking and financial institutions area. Our public company clients that have specific certain fund management entities that only deal in activist situations with financial institutions. So we have that. And then also well-known individual investors, the names of which many of us know, and some of which will go unnamed as well. But those are the players and kind of the basics behind it. But we also need to constantly ask ourselves, why is activism important? We get these questions a lot from clients. Why is this shareholder reaching out? Why did the board get this letter? And when you boil it all down, the answer, the overarching concept is really as simple as money. Most activists in the current environment engage in activism to increase the value of their holdings. And so obviously money is important. Activism does impose costs, both opportunity costs and actual costs on the company itself in responding to the activist situation. But activist campaigns can focus management. They can lead management and the board to reevaluate their strategic direction and their tactical approach to governance items that they otherwise wouldn't look at in a non-activist situation. So it is important, and it's fundamental. So, but when you boil it all down, again, it's always about money. And so it's a simple concept, I know, but one that, and I don't want to be too cynical about it, but that's really the fact of the matter. So, again, we want to kind of go through an activist situation, start with the mindset of the shareholder proponent, and then go through the analysis of how to deal with these situations. So, Michael, I'll start with you.
Sure.
Is it all about money?
It is.
Am I being too cynical about this?
Not at all.
I mean, what's your philosophy?
I'm in it for the money. Okay. There's many, as you say, I'll echo that. There's many flavors of investors, of activists. We've talked even today informally about ESG folks, a whole range. But at its core, it's a form of investing. All right. To my fellow kind of Wall Streeters, we describe it as value investing, or extreme value turnaround type of situations. And there's sort of two dimensions to it. There's the value dimension, where you know that there's an undervalued security, publicly traded U.S. equity for almost all the situations. But there's some obstacles that revolve around corporate governance or a law or statute that are preventing the value from kicking in, from the increase in value. Sorry. And the way an activist investor thinks about this stuff is, how can I deal with these obstacles? Are the obstacles at the board level, the executive comp, or their incentives that are backwards? But if it were purely just a value proposition without any kind of governance implications, it would just be purely portfolio selection. And there's lots there's just yards of material written about how to select a value portfolio. Okay, but we there's an extra step here where a portfolio manager that wants to dig into the proxy, understand some of the governance, figure out how the board works, and how those are an obstacle to gaining that value is where that portfolio manager is going to do their work. So when you ask the question, how do I pick one or another company? Both those dimensions need to satisfy some of the criteria.
Yeah, let's drill down on that. Because that's one of the first questions I always get as counsel of the company, again, on your decision to engage, I'll call it. Some would say go activist or go rogue. With a particular
I like to say escalate.
How do you decide
how we're going to escalate? How we're going to
How do you decide? Do you look at a depressed stock price situation?
We'll do all the screens and so forth. They do all the financial analysis that we need. Look at cash flows. Look at the balance sheet. But that's all kind of table stakes here. After that, we have to start looking at what's preventing this company from achieving its potential. 8 times or more out of 10, there's some problem at the board level. Okay. To describe it a little more formally, we talk about agency problems and so forth. I don't want to necessarily, handle that here, but there's some problems with how the board frequently, not always, is overseeing management, how they're allocating capital, how they're dealing with free cash flow, how they're dealing with extra cash. Okay, so much of the time, and anytime I look at this, I do a very thorough analysis of the board and try to figure out, what are they doing to try to exert influence or positive influence over the management team. So that's usually a very basic or advanced part of the analysis. So go ahead.
So when you've targeted your mark, I'll put it.
Mark. I also want to kind of lower the temperature of the discourse. When I've selected a portfolio company to escalate.
See, that's the point.
I really, and I mean that quite seriously. I'm not even flip about it, but there's so much of this. We talk about proxy wars and all sorts of very inflammatory language that is totally unnecessary, except in some of the more fun ones.
Okay. So you've decided upon your engagement.
Yes.
Engagee. What is the most common tactic that you would use in the current environment that you would find from your perspective as achieving the most, or is there
there's going to be 2. Okay. And then I'm going to leave it to others to kind of extend on this, I hope. The first tactic, the first thing is I want to start engaging with the board. Okay. As an investor, I want to start to be able to have constructive conversations with the board of directors. I've elected these people, I pay these people, and I want to be able to talk to them directly about what's on my mind and how they're managing the company. That's not always easy. We heard a little earlier about how boards are trying to be better at that, but there's many, many companies where they're not getting that message. Okay. The other tactic, and this is going to be I imagine this would be interesting to hear from a lot of the company folks, is I'm going to talk to a lot of other shareholders. I'm going to have discrete legal conversations with other big shareholders about what I'm thinking. Most of the time, I don't own enough to really have a dominant influence over. There are some shareholders that can, Paul Singer at Elliott or goes in and with his 10% at Southwest, he can get whatever meetings he wants and they will do a lot of what he says. I think, I'm not sure. Okay. For me and for most everyone else that I know, we need the support. We need the endorsement from other shareholders. So I will be having lots of conversations with them. Again, legal ones. I'm not going to be saying to them, "Hey, I'm doing a proxy contest. I'm going to start soliciting you now." That's not happening. Okay. I'm going to start having conversations like, "Here's my thesis for the company. What do you think? Do you agree? Am I right? This is what I think of these directors. Do you, or what do you think of these directors?" Or and so on and so forth. So because I want to start. If and when it comes down to it, I want those shareholders to be able, I want management to be able to call those shareholders and say, "This guy Levin called me. What do you think?" He said, "Listening." So those are the 2 dimensions. Talk to the board, talk to the shareholders.
And that's usually in the form of what? a letter to the board, letter to management, direct.
Sometimes I don't write
Show up
letters
on their
to
doorstep,
managers a whole
but-
lot. I'll have phone calls
Yeah, there you go.
with boards and other
Yeah,
shareholders.
yeah,
So,
yeah.
yeah. All right,
So-
let me leave it there and let
Yeah,
her-
yeah, but that's the perfect segue to, okay, so Chris, we have Michael, fires off a phone call to you or to more commonly to a board member, CEO, or he files a rogue 13D that nobody was expecting.
It's not rogue. It's just a 13D.
Well, as Chris will talk about here in a second, sometimes that does happen.
Yeah.
13Ds pop out of nowhere when nobody was expecting it. You've been involved in these situations before at Finish Line, companies with a visible presence. You've navigated the situation successfully to a conclusion that was beneficial to both the company and shareholders. What are the first few steps you as general counsel take when something like this happens, whether it's, a friendly overture or an unexpected 13D that comes in?
So what he really wants me to say is the first step is I call Dave.
I'm not
really,
that simple.
but really, but really, I guess you all know Mike Tyson, right? You've probably heard Mike Tyson's favorite line is everybody has a plan till they get punched in the mouth. I'm gonna flip that on its head. Get a plan, have your leverage pre-baked, pre-built. Poison pill, shareholder rights plan, have that done and on the shelf, right? So because the discussion's gonna happen and you're gonna negotiate and you want to have leverage. The activist is gonna come with leverage at that point in time. You just want to make sure you have your leverage. So that would be number one. And I agree with Michael. Most of these letters come into the board. They don't really want to talk to management, or they've already talked to management and they're going to the board for other reasons. So when it comes in, you have to recognize that that's usually a request to the board. So you got to say, hey, board, what do you want to do with this thing? And so as corporate secretary, you take the direction from the board, how they want to play it. So that's a sort of a practical scenario. And then you got to you got to get your outside legal advice to someone that has dealt with, depending on the nature and the severity of the activist that's coming at you. And Michael's other point was spot on. If he's coming and he's an outlier in the shareholder base, we're not going to give him much weight, or as much weight as if he's actually representative of a voice that's broader in the shareholder base. So having him do his homework before and like, hey, I've talked to a few other people, we're going to pay much more attention to that scenario. So those are the practical first steps. Make sure you've already got your shareholder rights plan on the shelf. And then
I only ask that shareholders be allowed to approve it after a year.
yes, I understand that. I understand that.
Cool.
And there shouldn't be any problem with that.
So having that preparedness plan,
Yep.
so to speak, is really important. And so you take those first few steps, you're prepared. In Finish Line's case, again, a very unexpected 13D with a novel derivative instrument disclosed came in. Chris handled it adeptly, educated as many people as he could on it. What was the board's reaction? What is the board's reaction when you bring it to the board in a situation like that? What's their kind of initial reaction, and how do you manage them in that situation?
Yeah, so from the corporate secretary, GC perspective, you don't want to be surprised. You don't want them to come at really basic governance issues like, why don't you have some retirement? Why don't you have tenure? Why don't you have independent role? Why, like the basic, low hanging fruit. So you don't ever want to be attacked on really basic 101 garden variety nominating governance issues, right? So it's usually something other than that. It's usually something that's caught you by surprise. And so you try to have the conversation with the board, like, no, we're solid here. We could go talk to Charles Ellis. He would give us an A+ on our governance program, right? So it's usually something else. And if it's been missed, then there might be a little bit of explaining to do from a management side. Why didn't you do this? Why don't you have that? And you kind of have to overcome that and realize that they're talking to the board, and the board needs to be able to have all the facts they need to have to make an informed decision as to how they're going to direct either management or how they're going to direct themselves to respond back.
Mm-hmm. So Professor Lipton, so once Chris gets the intake, takes the initial preparatory steps, gets the initial reaction of the board, now we kind of get down into the nitty-gritty legalities of what does the board need to do? What are the board's duties in any activist situation, and particularly in a situation that's unexpected? What's the board's role in this situation? What are the basic fiduciary duties?
Well, in general, the board has a fiduciary obligation to maximize the value of the company. So that means that if an activist comes to them, if they're gonna take action to fight off the activist, they first have to assess what it is the activist is asking for, and they should do a good faith assessment of whether the activist has a better idea than their idea. The board has to make some kind of judgment that if they're going to fight them off, that's because the board's plan for the company, in the board's good faith opinion, is better. And if the activist, for example, is proposing a sale of the company, the board should make an assessment of whether they really do have a long-term plan that will generate more value for shareholders than an immediate sale. And that's not always going to be the case. So the example Delaware's given is, if you're in the horse and buggy business, eventually you have to figure out that maybe this company shouldn't be around anymore. Like, there is an end point. So, so the first thing the board has to do is make an assessment as to whether, there's a good reason to fight off the activist. And if there is, then they're sort of somewhat limited in what their tactics are, because at the end of the day, if we're talking about a proxy contest situation, the board is not allowed to interfere with shareholder voting. Like, the shareholders are the ultimate decision maker. The board can take steps to make sure that shareholders are informed. They can make their case to shareholders. They can maybe even delay the meeting to make their case to shareholders if necessary, up to a point. But what they can't do is something that's going to actually sort of undermine the shareholder vote itself. That's where their power stops.
Yep, and that's a good segue. To you, Tiffany, again, one of the most tried and true tactics in an activist situation, perhaps not Michael's preferred way to do it, but been used for decades, is a traditional proxy contest. So
no, don't like those.
Again, the activist comes in, the board is informed, the fiduciary duties are gone over. A proxy contest is actually in play here. The filings are made. In your position at the commission, I mean, you have a front row seat to these matters, obviously, on a regular basis. But from your perspective, what are the most important portions of the proxy rules that companies and shareholder proponents need to focus on when considering a proxy contest?
Yeah, thank you. And I'll just insert my quick disclaimer before I begin. So my remarks today express my views as Chief of the Office of Mergers and Acquisitions, but do not necessarily reflect those of the commission, the commissioners, or other members of the staff. And thanks. I'll start just by saying thanks for inviting me to join. So in terms of the most important proxy rules, I think as a regulator, I would say all of the proxy rules are important. But you are correct that there are certain rules that play a significant role in proxy contest. And first, I would start with 14A9, which, as many of you know, prohibits material, false, or misleading statements or omissions in proxy solicitations. That one is certainly important, and parties really should pay special attention to this prohibition as they are making their case both for, or I guess I should say either for or against change in their fight letters, as well as in other communications that are filed under the proxy rules. And we on the staff certainly appreciate the importance of allowing the parties to fully debate the issues. And our goal isn't to interfere with that process or to determine who's right or wrong in that process. But still, parties must be careful that they're not making claims or accusations of wrongdoing without having an adequate factual foundation. And so you'll see that many of our comments on proxy contests, particularly on soliciting material that's filed either before or after the proxy statement, are targeted at potential violations of this rule, and that's 14A9. And then it should come as no surprise that following the adoption of the universal proxy rules in late 2021, it's crucial that parties comply with Rule 14A19. And that's the rule that prescribes certain deadlines for the parties, a minimum solicitation requirement for dissidents, as well as formatting and presentation requirements for universal proxy cards. And there are a number of other rules that are, at play in proxy contest. Of course, the Schedule 14A item requirements, but particularly items 4B and 5B, which require in proxy contests more detailed information about the persons who are making the solicitation, as well as more detailed information about the interest of participants in that solicitation.
So with that as the backdrop, Tiffany, what are you seeing? What is your office seeing as the most common issues and perhaps mistakes that companies and shareholder proponents are making with respect to proxy contests and the filings that you're seeing? If you're able to comment on that, what are the biggest mistakes that you're seeing?
Sure. So rather than sort of framing them as mistakes, really the sort of most common areas of comment, if you will, I think because the universal proxy rules are still fairly new, as you know, we have our sort of third season that's coming up under the universal proxy regime, but because it's still fairly new, the staff remains very focused on ensuring compliance with 14A19, as well as, and part of that is focusing on the disclosure regarding a shareholder's voting options and the voting mechanics. And our comments have reflected that focus since the effectiveness of the universal proxy rule. So I do expect that to continue into this season. And then, as I mentioned, of course, 14A9, certainly a common area of comment and where we see folks sort of go astray in terms of lacking that factual foundation, or at least the factual foundation for the claims of wrongdoing or other accusations isn't clear or evident in the filings. Or, as you know, it's possible we might have received a complaint letter from the other side, indicating that such claims are false. So that's another particularly common area of comment. And then another issue, I wouldn't say it's a common issue in contests, certainly not now, but it does have significant implications for the parties. And that's failing to file a preliminary proxy statement when one is required. And we have seen this recently. For example, in a case where the dissident, I should say, has filed a preliminary proxy statement, but the company chooses not to, it elects not to go straight to definitive, and they're, relying on the fact that they have rejected the dissident's nominees, the company in that case would be required to refile in preliminary form, because in that situation, the dissident's proxy statement constitutes a solicitation in opposition under Rule 14A6. So that's one, like I said, not super common, but significant implications for the party. So good to keep in mind.
Yeah, that's terrific. I was going to go to you next.
No, I'm just.
No, I was, but.
Oh, great. I'm all ears.
Yeah, so just hitting on Tiffany's comments on universal proxies, and
Yes.
they are new.
Big fan.
And well, you read my mind. That was my question. Is this a development for you and others on your side of the table that you found helpful when the rule was initially passed? Have you used universal proxy?
All the above. Yes. Welcomed it. It's in retrospect, a very logical and sometimes, easily implementable improvement in not just how it helps me activists, but it helps voting shareholders. Okay, that's really the point, was to help voting shareholders essentially be able to vote on director candidates in the same way they were if they were to have attended the meeting in person. Mm-hmm. And that's very clear from how the SEC laid out the reg. Mm-hmm. And so taking off from that, it was something that a lot of activists had been kind of agitating for a while, something the SEC had been thinking about for many years. And then, the wheels of regulation turn slowly, but they work well when they work. And it finally happened. Like I said, I was a big fan. I wrote about it, and there's a little website I set up as a resource, universalproxycard.com, that you could go to, that's got all sorts of resources on it. I was a real fan of this, and I knew that it was going to have some serious implications for activism and proxy contests and corporate elections. It was not a way to spend a lot less. It didn't it reminded us that an activist didn't necessarily have to spend a lot to run a proxy contest, but we have continued to see that it still takes a significant amount of money to win one, if you go to a voting outcome. And I'll leave that last point. Very many fewer contests are now going to voting outcomes. That there's been a dramatic increase in the number and the speed at which issuers and dissidents, companies and activists are getting to some sort of amicable settlement of these. They don't necessarily want to kind of try the boundaries of this. They don't want to necessarily see how it could work in the places, and I've studied this, the places where it has gone to a voting outcome, it's very much binary. Most of the companies have basically prevailed. And in the places they haven't, the activists have won everything they've been looking for.
And to that
So
point,
go ahead.
did universal proxy, when it came out and over the last 3 years, did it push you to perhaps undertake an engagement situation more so than you would have without universal
Not
proxy? Did it push you
necessarily.
over the
Yeah,
edge?
no, money activists probably weren't going to, maybe at the margins, there might be a couple that kind of were pursued because they said, okay, universal proxy would make it a little easier. But most activists that were value investors were going to go down some sort of an escalatory path where universal proxy kind of made life a little easier. There was, and I was among these people who thought when the reg was first issued, that, there's going to be this whole crowd of unconventional ESG single issue activists that were going to take advantage. They were going to sort of hear that, proxy contest is a lot cheaper now, and they were going to jump into it. That did not happen.
Yeah.
There was like one. That was the Starbucks situation earlier this year.
Yeah.
But it has not kind of brought all these, smaller first-time novice, activists out of the woodwork.
Yeah. It's interesting.
So yeah.
I mean, and from your perspective, so let's say it does push some activists to become more activists in a situation they otherwise wouldn't be. And, boards get outreaches from various different activist angles. And again, this is a question I get from a practical perspective all the time is, does the board have a specific duty to engage with activists, whether they come in through just a letter or a phone call, or even, more notably through a 13D? Is there a specific legal duty that the board needs to engage with these activists?
No, it's more like the board has a general duty to protect the company. And so they have a lot of discretion to decide what steps are appropriate when they want to protect the company. So if you're thinking about, let's say 14A8 shareholder proposal, somebody submits a shareholder proposal. Lots of boards say, I'll put it on, especially because a lot of them are precatory. And that's fine. They may not think it's the kind of thing that warrants a huge protective response. But if it's a 13D and a tender offer, like another extreme end, a tender offer, well, Delaware's been really specific. You can't just, there's also federal law, but you really just can't sit there and say, okay, well, whatever. You have a duty to assess this. It's a big deal. You have a duty to assess this and tell your shareholders what you think. So it's the same thing on any other kind of activist situation. They have a duty to protect the company, and that means if there is some kind of very significant movement happening, they have a duty to assess it and, if possible, give guidance to shareholders and so forth.
And when the activist situation involves something like, Finish Line and Chris endured, where it became somewhat evident early on that this perhaps was an eloquent manner of a takeover attempt of the company. But it's not necessarily clear at the forefront. What are the legal standards? Does the board have a duty to do a market check, or perhaps consider strategic alternatives, hire an investment banker? Not should they, because they probably should, but do they have does the board have a duty to take those steps? And if they don't, are they putting themselves in more legal jeopardy than they should have?
Yeah, again, it depends on what's on the table. They have a duty to protect the value of the company and protect the shareholders. And what that actually involves really is going to depend on the nature of the threat. So if somebody's making an offer to buy the company, they have a duty to assess that offer and take that seriously. And that may mean that their duties of care and loyalty require getting an outside financial advisor. If it's reviewed later, it's complicated, the procedural barriers to just a lawsuit, but if it's, that's going to be assessed according to, did they act on an informed basis, which is part of their fiduciary obligation. But this is coming all from, state law, which let's assume Delaware law, 'cause that's all I know anyway. But Delaware has been very clear that there isn't like a defined, you must do these steps. The board's a lot of discretion to make those judgments.
Yeah. And that's helpful because there are a minority of states, I practice in Indiana, and Indiana has an interesting portion of its business corporation law that specifically repudiates the Revlon duties when it comes to, control situations. So in theory, there's more flexibility for boards to consider different constituencies in those situations. And I know there's a few states as well that have that constituency statute, Maryland, another one.
Most do, actually. I think it's more than 30 do. And what that means as a practical matter is that if you, when selling the company or even making any decisions about the company, you do not, in fact, have a duty to maximize the value for shareholders. That said, studies have suggested that it doesn't really make a huge difference in terms of how boards react. They do tend to try to maximize value for shareholders, and it doesn't matter whether in a constituency statute state or not.
Yeah. That's great. Tiffany, back to you. From your perspective, you talked about the principal proxy rules. I guess I have two questions for you. Back to universal proxies. Are you seeing anything from your chair on trends in the use of universal proxies from kind of a 10,000-foot view? Are you seeing it used more? Is it going to take more time for participants to understand how to effectively use them? What's the thought on kind of the trend lines in universal proxies?
Sure. So less in terms of, trends specific to the use of universal proxy, but we certainly observed a couple of interesting things about this last proxy season and the proxy contests that occurred under universal proxy. And I would say, so less directly related, but there's certainly an interplay. In this most recent season, we saw a significant increase in the focus on advance notice bylaw provisions in terms of director nomination notice rejections, challenges to the provisions in court. And we saw that play out in our SEC filings. And I can say that the staff is definitely monitoring this space, given the potential for gamesmanship. And like I said, the interplay with universal proxy contests. So that's an important area for us, and one we observed a significant increase in all of that playing out in SEC filings. We also saw a slight, I would say, so slight uptick in vote no or withhold campaigns. And there, how it impacts filings in particular, depending on the specific facts of the particular contest, it can lead to, I would say, some interesting questions on the presentation of voting options on the proxy card. So there's often in those cases comments around how the voting options or other disclosure on the proxy card is presented to shareholders, primarily to eliminate any type of confusion. We also saw this proxy season a much more uniform approach to the treatment and disclosure around undervoted and overvoted proxy cards, which many of you may know. We published 3 new CDIs before this most recent proxy season, clarifying how overvoted or undervoted proxy cards should be treated and the disclosure around that. And so I do think those CDIs were successful in clarifying the application of Rule 14A19 as well as discretionary voting authority under 14A4 in those situations. So that was certainly nice to see. And to that end, I'll take this opportunity to note that as with each proxy season, we assess whether there are any issues or questions that arose under the new universal proxy rules that would benefit from guidance from the staff. So I would just encourage folks to reach out to my office with questions, or if there is what you deem sort of a big issue and something that really warrants the staff's attention or guidance, please don't hesitate to reach out, because that's what we're here for.
And you kind of anticipated my next question, Tiffany. Are there any of those big issues that, I know you're not a policymaker per se, but are you seeing big issues come across your desk that perhaps may result in additional CDIs or additional discussions on refinements to the rules, whether they be universal proxy or 14A9, 14A8, any of those situations that you can share or orient us in a particular direction to expect?
Yeah, so nothing I can speak to in terms of what to expect or what might be in the pipeline, but I can say with respect to 14A19 and universal proxy generally, the rules are largely working how we intended and anticipated, to be honest. I was actually at the commission at the proposing stage, so that's obviously nice to see. I sort of missed the adopting stage and then came back for the implementation stage, which has been fun. But by and large, working how we wanted them to work and anticipated. Even something like the 3-way contest we saw at Disney this past season was something we had contemplated when putting the rules together, and they worked and they provided the flexibility to allow that to happen. With that being said, each season we are seeing novel situations, and in each of those situations, there is close attention paid to, again, primarily the disclosure around voting options, treatment, making sure shareholders are not confused in any way by what their options are. And so I fully expect, folks to continue to bring issues that warrant or could benefit from staff guidance to our attention, and I hope they do so. But currently, I'm not aware of any sort of what I would call big issues with the current rules.
Yeah, that's great. And again, I gave Michael's website address earlier, and in full fairness, to promote the Securities and Exchange Commission. They have a great website too, sec.gov. Visit it. There's a lot of information there. And so I encourage everyone to visit it. But in the time we have left, kind of as to bring it all full circle, kind of final thoughts. Chris, I'll go to you first on the preparedness steps from the company's perspective. When you have an activist situation, what are the best preparatory steps that a general counsel can take, whether it's substantive engagement with shareholders? The last panel had very good salient points on that. What are the best prep steps?
I would say, Gal, just reinforce the basic 101 on governance, that you're talking with your shareholders, you're holding your earnings releases, you're open to Q&A, you've got the right structure in your bylaws, in your director and tenures and all this sort of stuff. And you're explaining their bios and why they're there. You're not stale, you're switching your directors out. So you look good on that, right? So you're not on this face, you don't look like you're assailable, for sure. If you don't have the shareholder rights plan, what's helpful is to have a tabletop exercise with your board. Like what would happen one day if somebody came, are we ready? And what would our plan look like? So organizations, I'm not seeing a ton of folks that are like with corporations or organizations in this room, but you have tabletop exercises on a cyber breach, data breach, like what would you, ransoms coming in. So you would just role play it, have a tabletop exercise with the board, like this is what happens, who's the first to call, what should it be? And that's naturally why, well, do you have a plan? You don't have a plan. Well, maybe we should have a plan. So I would tabletop the exercise and then fill in the gaps in the holes that you have in what the appropriate steps would be.
Yeah, and that's really good advice, if I could call it advice. Because everybody's so busy, you're so busy as a GC that oftentimes it's hard to kind of make that decision to sit down with management and the board and have that tabletop exercise. But it's kind of like military training. The
Yeah.
more you do and the best, it really works out.
Yeah, and if you're obviously having quarterly meetings, but you have once a year, you can put that on the agenda.
Yeah.
Just once a year, just touch base. You've already done your first initial one, then just touch base, just test it. What else are we missing? What isn't in our last? What have we learned based upon the new rules that have come out? What's missing in our tabletop plan, response plan? You all have continuity plans, just your business operations, and this should just be a part of that for the board.
And what do you think? Is that helpful to the board?
Yeah.
From a fiduciary perspective?
I'm sure it is. What I would add, though, I mean, here's the thing. So universal proxies obviously scared a lot of boards. And you mentioned rights plans a couple of times. And the problem there is that it's not exactly clear what boards can do with rights plans when it comes to a proxy contest.
Right.
We know what they can do with rights plans when it comes to a takeover attempt, which is just about anything they want to. But when it comes to a proxy contest, they can't interfere with shareholder voting, which means you can't drop a bill, the point of which is to interfere with the vote. Or to put another way, like essentially, if you think of the Williams case, like you can't drop a bill that's like, if you say hi to other shareholders on the street, they're part of your group and the pill triggers. I mean, you can't do, you can't do a pill that's the point of which is that prevents shareholders from talking to each other so that they can hold a proxy contest. The few times when pills have been permitted in a proxy contest situation, it was because of a fear that if the shareholder got too much control, they'd essentially, be able to take over the company without having a proxy contest and without paying a control premium. So advance notice bylaws have become the sort of substitute because you're not really sure what a pill does in this situation, and we're talking about a contest. And that's really something that you can set up in advance. And the warning, though, that Delaware has given very recently is advance notice bylaws are fine if you're genuinely trying to elicit information. Who are these people? What are their qualifications? What are their interests that haven't been disclosed? Which shareholders are they talking to? Are they net long or net short? Like that kind of information is information you're permitted to get, but you can't drop an advance notice bylaw, the purpose of which is essentially to require so much information that no one can possibly answer it, and you're stopping the proxy contest. So it's this very delicate line that boards have to walk.
Yeah. That's a great point. And Michael,
Yeah.
kind of what's your takeaway? What's your final piece of advice? Because I tell you, I think the biggest mistake from my practice and, what I see out there with companies is that the mistakes when it comes to shareholder activist, shareholder engagement happen long before an actual activist situation arises.
Yes.
It's because
I have
of
to echo that.
not really paying attention to your shareholders, not paying attention to engaging with your shareholders. So what do you leave for companies from your perspective?
The best piece of sage advice I could give at this point would be, instead of adopting a pill or instead of strengthening advance notice bylaws, take the call. Okay, most activists want to have a conversation at the right level, in the right forum with the directors, kind of no holds barred, because usually, again, this is value situations where there's problems. We don't go after companies most of the time that are doing really well. It's, because other shareholders aren't going to support us. Okay. But take the call. I'm involved today in one of my projects with, our team is really trying to engage with a small cap company, and they're not taking the call, and we are getting pissed off. And for us, it's a little slice of our portfolio. It's going to be costly, But it's, if we decide to escalate in the same way we're talking about, I'll use the, nice verbs. It's going to cost us some money, but it's not going to cost us a whole lot of reputation, win or lose. For this board, we're prepared to make them look really bad because they're not taking the call. They refuse to engage. Like, and in this situation, we're about to proffer a books and records demand. And we did an informal, we called, we said, this is not a books and records demand for board of directors minutes, for really confidential sensitive stuff. We just want a shareholder list. We want a shareholder list and an OBO list. Okay. They're refusing to engage. And we're getting more and more irate as the days pass.
Yeah.
And so if they
Us who that is David and I need to apply.
I'll give him I'll send him your card. Now I think they probably can't afford you.
Oh, sure they can. I mean, but the,
I have a quick
Yeah, go ahead.
question about this, because you
Go ahead, sure.
no, just sort of in general in your approach. So you talked about it'll cost you some money and so forth. Like, are you ever sort of willing to launch, escalate, shall we say,
Yes.
less because of the value that you see that comes from it, and more because you want to make sure that the next board knows you're serious and they need to listen to you?
The latter does have to do a little bit with our thinking, but it's mostly because we've got I mean, again, we're doing this pretty systematically. We have a model. We know what this company should be worth. We know what they're not doing well. We know what we know what to happen, and we're pretty sure we understand the obstacles here. And we're willing to talk candidly, confidentially, discreetly. We've made some SEC filings here, but we've been very careful to not embarrass the company in how we've done this. We've not issued any press releases. We've not done any public letters. There's no fight letters. I hate that word. Okay. And still they don't want to engage with us. And it's gonna get worse.
yeah.
Okay. I've always said a long time, to be an activist investor, you got to have a very thick skin. You you can't really care what people think of you. And I know. So.
And that brings
We're not
us-
those people.
And again, before we get to some
Yeah, all right,
questions.
let me shut up here.
But no, that brings us full circle to kind of the ending themes, takeaways from this. Number one, from Chris's perspective, preparedness. We don't give enough attention to preparing for these situations, even when they're not at the forefront, even when they're not on the front burner. So preparedness. And then, as Professor Lipton really made clear, make sure you pay attention to your duties and what the board is supposed to be paying attention to on a day in and day out basis. And from Michael's perspective, engage with shareholders. And that will pay dividends in the long run on both sides of the ledger. And pay attention to the rules from Tiffany's perspective and be willing to reach out to the commission. I've learned over the years that outreaches to the commission, it's not that scary, okay? They are more than willing to take your call, be prepared, do your research, but they are experts at what they do, and they are very, very helpful in so many different situations. So with that, I'll be quiet for a second and happy to field some questions in the time we have left. I know we only have a couple minutes, but happy to take any questions for any of the panelists. Sure.
I'm curious, what does healthy engagement and dialogue look like? Obviously, you've done your analysis from the outside looking in, and presumably whoever you are trying to escalate with will take your call.
Yes.
And there must be a point where reasonable minds can differ. And
Absolutely.
So what does that look like?
A healthy, candid, confidential discussion with directors. Okay. Again, my view is I elect them, I pay them. That's who I want to talk to. They're my elected representatives in terms of stewardship of this company. Okay. If they in turn and want to talk to me, I really want the CEO in the room, or I really feel more comfortable there's a lawyer here or something. I may question their ability to talk person to person by themselves, but I kind of get it. Okay. I understand that they don't want to talk about M&PI. They don't want to talk about personnel matters. I still think, I maintain that directors have a lot of things that they can talk about the tone, what's going on in the boardroom. Okay, maybe not talk about very specific decisions. And I'm going to want to ask about capital allocation, investment policy. I'm going to want to ask about a use of cash and cash return. Most of these companies have plenty of cash. And there's a, as we say, there's a famous paper, The Agency Cost of Free Cash Flow. I'm interested in that cash. Okay. I want to have those kind of constructive, and it's not one meeting. Okay. I have never had a director say, here's my mobile phone number. You can call me anytime you want. Okay. And I'm not going to abuse that. I'm not going to put it on the internet. If I have a question, that's what I want to be able to do. I want to be able to have that kind of one-on-one relationship with that director. And I'll tell you a payoff from that. Okay. If a company started doing that months or years before, not just proxy season, but a year or two before, and started exposing directors constructively to shareholders that way, then when I show up, it's going to be really hard for some hedge fund or pension fund to vote against that director if they already have a personal relationship, if they already have their mobile phone and have already started developing a relationship. But, you know, in a company that happens, I'm not going to be that interested anyway, because it's probably pretty healthy in the first place.
Hey, Michael, real quick, and
Yeah.
I know we're at time, but I think this is important, and it's a holdover from the last panel. You mentioned M&PI and the Reg FD situation.
Sure.
This is a common question that I get a lot as well. What you know, and your colleagues on the activist side know that the company's not going to be able to disclose M&PI. I mean, you know that,
Right.
they know that.
Absolutely.
What do you expect them to be able to talk about with you before you hit the
Well,
Reg FD?
MNPI is there is some discretion, there's some judgment around what kind of counts. Okay. And anything that affects kind of my thesis or my ability to prosecute the governance part of this probably isn't MNPI. Okay. There's stuff about what goes on in a boardroom, stuff about what they think of executives and so on and so forth that I think is a legitimate thing to have a discussion between an investor and a director. Otherwise, everything's MNPI. And, you know, I just have to rely on public filings, which, you know, there are companies where that happens.
Yeah.
So
Yeah, that's great.
all right.
Well, I know we're at time. There was a lot there. It's like standing under a waterfall with a teacup, but we'll be available afterwards
Yeah, I'm here.
for more questions and interaction. Special thanks to Tiffany Posil from the commission. I'm so happy she was able to make it. To Michael Levin, Professor Lipton, Chris Eck, thank you very much.